Help their criminal warriors. Oops. What happens if you forget to respond to some type of court notice or a court hearing? Well, it can vary widely based upon the type of notice or hearing that you sort of messed up. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years. I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get the help they need. Now I'm just going to jump right into it. Sometimes we just make a mistake and we have, a mental letdown, a brain fart, they say, and we, forget to respond to a court date. We don't get a notice of a court date in the mail, and we just sort of forget about it. Or when we remember it, that we miss something and go, oh my God, what happens now? Well, I'm going to go over the most common situations and what happens and then what you need to do about it. And so I think the first one that's the most obvious is, let's say we miss a summons to go to court for a criminal matter. What happens in that situation? And some of you may know that already, but there's a couple different nuances to it. So if we have been, accused of a crime and we get sent a notice for an arraignment to go to court, sometimes we miss that notice. We were out of town, it goes to the wrong address, it's got the wrong name, we never even get the notice. Well, what happens when that criminal matter, that means something that's a crime, the court date comes up and we're the defendant and we don't show up? What happens? Well, most typically the court issues a warrant for your arrest. What does that mean? The court signs an order that says, hey, law enforcement, if you see Mr. or Mrs. defendant that's accused of the crime that missed the court date I told them to come to, arrest them. And there's usually an amount of bail on that warrant. The bail might be $5,000, $10,000, $100,000. That means that if the law enforcement officer happens to find you, then you're going to get put in jail. And to get out of jail before you see the judge, you're going to have to post a bond or bail. We have videos about that, about how to do that. You can use a bonding company. You might have to post cash bail. But if you get arrested, you're going to have to post to get out or wait to see the judge and explain it. Hopefully, then they let you out. All right. Another situation is you've made it to a court date and the court case gets continued and you sort of mess up and don't show up at the next court date. Well, in that case, you probably have an attorney. If you're missing the second court date on a crime or third or fourth, you likely have a public defender or a private attorney. Now, what should happen is the court should issue a warrant, but it may not do that. The attorney may be able to say, Judge, can you note the non-appearance of my client? I've had good contact. This must be something that slipped their mind. Maybe they're in the hospital. Who knows? Can you note their non-appearance? And we'll explain it next time. Just move the court date. So don't assume you have a warrant if you already had an attorney, but reach out to that attorney is what you need to do right away to find out what happened. And if there is a warrant issued, your attorney may be able to file a motion to quash the warrant. That means remove it, go to court and explain without having to pay money to the court. Wouldn't that be nice? And in some cases, when we have a warrant for arrest, some courts will let us do what's called call it either a walk-in calendar or to sign for a new court date. And it varies court to court. And I have videos around in my channel that talks about quashing warrants, but just the short version is this. Some courts will let you come into the court and either sign for a court date or pay a small fee for the inconvenience, pay $50 and sign for a court date. Some courts will let you come in and get on a walk-in quash calendar. Well, if you walk in and tell them you can, without filing a formal motion, they'll give you a date to explain to the court to remove the warrant. So I get asked questions, well, if I walk in, are they going to arrest me? I've never seen it happen in 30 years of doing this type of work because I was a prosecutor before the defense side. So probably not, they're not trying to trap you. It's just a lot of hassle to arrest people. They're just trying to get the case back on track. So when you miss that criminal court date, we have to worry about being arrested, warrants, stuff like that. Well, what other type of court dates are there to miss? Well, there's two others I want to cover here. One is restraining orders, where someone's trying to get a restraining order against you, or you're the person trying to get a restraining order against someone. And the second is traffic tickets. Traffic tickets are probably more common, but I deal with more of the restraining orders than traffic tickets, so I'm going to start with restraining orders. I'll make it quick. If a restraining order is a civil matter, and so in the civil law, when one party doesn't show up, there's basically a default. So if the respondent in a restraining order doesn't show up, then usually the petitioner gets his or her relief. There's an order that gets granted against the respondent, assuming they were properly served under the rules. If a petitioner doesn't show up, they get defaulted, which means their action gets dismissed. So if you miss a restraining order appearance, it's more catastrophic. There's no just like warrant you can quash. It may just end the civil litigation in a way you don't want. So it's important that you do make all of those court dates. Don't miss those. And then finally, traffic tickets. Okay, this is the most common one. A lot more people get cited with traffic tickets and get charged with crimes, right? So when we get a traffic ticket, we have a certain amount of time to respond to the ticket. If we don't respond to the ticket, then it's sort of like a default in that civil case I just mentioned, right? They'll find the traffic infraction committed. They'll usually add on an extra administrative fee, and then they're going to tell the Department of Licensing about it. You have so long to pay it, or the Department of Licensing will suspend your license for not paying it. If you do request a hearing timely on your traffic ticket, and either mitigation or contested, and you don't show up for the hearing date, well, again, it's a civil matter, so you get defaulted. They will find the infraction committed. They will charge you the amount of money on the infraction plus some more money, some type of inconvenience fee, an FTA fee or an FTR fee, failure to appear, failure to respond. Different courts call it different things. And again, they're going to tell Department of Licensing that you didn't respond. And now they're going to, DOL, Department of Licensing, is going to send you a letter, pay this by this date or we're going to suspend you, right? So when you don't respond to those cases, they're civil, you'll get defaulted. It's a little more possible to try to pull that one back. You might be able to write a letter to the court explaining and try to get back on the calendar, because it's not like one person versus another. It's the government, and the government, believe it or not, can be more forgiving than an individual litigant, a person litigant. So it may not be the end of it. You might be able to try to drag that back, and you might be able to try to drag it back with an attorney, but usually just end up paying the ticket and do what you can to avoid your license getting suspended. So those are the three areas I wanted to cover about what happens when you miss a court date. And you can see they're quite different. And if you're not sure what's going to happen, just call an attorney. So if you find this useful, please like and please subscribe. More people get the help they need. More importantly, if you've got a case out there, if you missed a court date, especially a criminal court date where you're defaulted, there's a lot of strategy we need to use. I've had cases that have been at default or a warrant for 10 or 12 or 14 years, and we can still often save those if we take the right approach. So if you're afraid, you try to get brave, try to reach out for help, and we'll do everything we can. We'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.